Hey everybody, welcome back. Gabriella Huffman here to help you study for your North Carolina real estate exam. Tonight we're going to talk about chapter 5. There's a lot going on in chapter 5, so I'm just going to keep to the point of what you need to take away. So chapter 5 is talking about the transfer of title to real property. This is a summary slide of your takeaways. So we're going to talk about transferring a property, also known as alienation. Make sure you know that word, whether it's voluntary or involuntarily. My O's and my E's, there's a really fantastic chart on page 86. I recommend that you put a bookmark there. We'll talk about requirements and non-requirements of a valid deed and what excise tax is. Out of all the deeds in the book, the ones listed here are the ones that you really need to know. And we'll also address title insurance. So a deed can be transferred voluntary or involuntarily. So based on the chapter, I went ahead and just did a quick chart on how voluntary and involuntary transfers can happen. Escheat, they talk about in your book, this is when someone dies without a will and with no heirs. So there's little asterisks there. So at the bottom, make sure you read North Carolina Intestate Succession Act. They may ask you about this. So this is when someone dies without a will. If there are heirs, then it will be distributed appropriately. If there are no heirs, then the property will go to the state through the process of escheat, in which the state will make a will and distribute from there. Wills must be made by a mentally competent person. And what's in red is what we talked about in chapter 2, where when you have joint tenancy or tenancy by the entirety that has the right of survivorship, a will cannot affect that tenancy. So in North Carolina, for example, when property is owned by tenants by the entirety, it cannot pass by will. So remember in chapter 2, if you have spouses, one of them passes and has a will, it doesn't dictate to the will, it's going to pass to the other spouse because neither spouse can disinherit the other spouse by will. A few other things to take away. Gift of real property is called devise. The person who's receiving that will be the devisee. Gift of personal property is a legacy or bequest, and a person who's receiving that is the beneficiary. Here's page 86. This is a snippet from that chart there. Please make sure you go and study this. This is all over your test. Your or is the give or, as I would say in my classes. Your E is the receive E. So in a deed, for example, for chapter 5, your giver, your grantor is the seller. The person receiving the deed is the grantee, also known as the buyer. Your book goes into detail about what's required for a valid deed and what is not required. So what I did is I highlighted in red your big takeaways. So what is required to have a valid deed is the identification of the grantee. But notice that the only person required to sign would be the grantor. What is not required is the recordation of the deed. So yes, you can have a deed and it to be valid and not recorded. But I put a little asterisk here to say, don't forget about the Connor Act. Make sure you go back to read that. The Connor Act does require grantee to record the deed to protect their interests as to third parties. So make sure you go back to read that it's not required, but a grantee would be highly recommended to do so to protect their interest. These are the 3 main deeds you want to know. General warranty deed, which have 5 covenants. I've highlighted in red the ones you need to know. Special warranty deed is also called a limited warranty deed. Notice it only has 2 covenants as compared to the general warranty deed that has 5. And a quit claim deed has none. This is a non-warranty deed. Another deed I want to make sure you highlight in your book and read about is on page 91, a trustee's deed, also known as a sheriff's deed. This will be given to the purchaser in a foreclosure sale. Title insurance, there are 5 things you need to know about: who the insured parties are, lender, owner, and any other interest holder. Buyer, if they're getting a loan, also known as the borrower, be paying for the owner's policy at closing. This does not terminate. It is for the lifetime of the owner, even after they sell, and to their heirs after they pass away. The buyer will also pay for the lender's policy, which does terminate when the loan is paid off. Title insurance is a one-time fee paid at closing, and it's only going to cover for title defects that were undiscovered before closing. That concludes your takeaways for Chapter 5. Have a great night.